All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and His honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. On today's docket, we have two cases. The first case we're going to hear here in the courtroom. The second case we will hear virtually at 10:30 this morning. Before we take up the first case, however, I'd like to note that Justice Muniz cannot be present in the courtroom today. He is, however, observing the argument and will be participating in the decision of this case. I also want to extend a welcome to Justice Coriel and Justice Grosshans. Justice Coriel has been a member of the court for more than a year. Justice Grosshans has been a member of the court for almost a year. They have not until today been out on the bench here in the court due to the pandemic and the extraordinary circumstances under which we've been operating. So I welcome them to the bench. Again, as I've said before, in virtual proceedings, so we value their contribution to the court. But I know they've been looking forward, as all of us have, to being back on the bench here in the courtroom. So with that, we will take up the first case on the docket, Bell versus the state. Counsel.
Thank you, Your Honor. May it please the court, Barbara Becheras representing Jesse Bell, and I've reserved 5 minutes of time for rebuttal. Your Honors, this case is about mitigation. How much is enough? How much is too little? And where are the limits of allowing a defendant to waive or severely limit the mitigation that a trial court considers when sentencing that defendant to death? The individual right to choose the goal of representation is sometimes at odds with the court's responsibility, and this is one of those cases. No one disputes that Mr. Bell had a right at trial to direct the direction or control the direction of the presentation of mitigation. But there's more than that at stake here. There's also an Eighth Amendment right and an Eighth Amendment concern for the court and for society in general that the death penalty not be imposed erratically, arbitrarily, or in circumstances where there is compelling mitigation weighing against it. When you go too far in allowing the defendant's autonomy to prevent the court from considering mitigation, then the Eighth Amendment concerns are no longer respected, and both of those are important and have to be considered.
Counsel, would you be able to, on this topic, distinguish this case from this court's recent decision in Kraft? How would you kind of distinguish how we address the mitigation issues in Kraft with this case?
Your Honor, I think one of the biggest distinctions between this case and Kraft is that in Kraft there was significant mitigation in the record. There was significant mitigation for the court to consider. And even though there were specific instances of mitigation or omitted mitigation that the defendant challenged on appeal, there were still a number of pieces of record evidence that the court could point to in explaining its decision and its weighing of the aggravation and the mitigation. Here, the mitigation was so limited as to almost be a total waiver, but not quite. Mr. Bell deliberately, it appears from the record and with thought, presented an extremely limited mitigation case. He called no witnesses. He said he didn't want to drag his family into court just to say that they loved him. He didn't cooperate with the pre-sentence investigation, and as a result, what the court had in front of it in this case was much more limited than what the court had in front of it
Counsel,
in Kraft.
Is mitigation somehow different? That is, I think you'd agree that if Mr. Bell had decided, if he had an alibi defense and had elected not to present any evidence of it, but let's say the alibi was, turned out to be a very good alibi, but exercising his Sixth Amendment right to direct his defense, chose not to put on the alibi defense. I believe you'd agree that that would be a permissible choice under the Sixth Amendment to him, right?
Yes, Your Honor.
Okay, so what is it about mitigation that makes it different and that puts us in a place where he is no longer reserved the right under the Sixth Amendment to direct any aspect of his defense?
What's different, Your Honor, is that death is different. What's different is that the goal of the mitigation.
But let's assume both things are. It's still a death case, right? So let's assume that instead of talking about a mitigation argument, he's talking about a prior offense and how it should be scored, or any other component of his sentencing. You still would argue that mitigation is somehow different.
Yes, Your Honor, I would argue that mitigation is different because the U.S. Supreme Court's Eighth Amendment jurisprudence makes clear that mitigation is essential for the individualized sentencing determination that has to take place before the death penalty is imposed. And when mitigation is too limited, as this court recognized, I believe, in Muhammad and Marquardt.
Am I wrong in understanding that the jurisprudence from the U.S. Supreme Court focuses on the exclusion of mitigation that a defendant wishes to put on? And that's problematic.
Yes, that is true, Your Honor.
That's what the Supreme Court cases talk about.
But to date, the U.S. Supreme Court has not said that it is constitutionally permissible to execute someone by ignoring mitigation either. So this is not a case, you're correct, it's not a case where mitigation was excluded over the defendant's objection. But when you go back and you look at what the court has said about mitigation, from the beginning of the current death penalty regime after Furman, the court has repeatedly emphasized the need for an individualized sentencing determination as a part of the sentencing process. I believe it was Woodson that said it was a constitutionally indispensable part of the sentencing process. And so the question becomes, when you have a defendant who wants to control the presentation of his case in a certain way, where is the limit of that when you run up against the Eighth Amendment requirement of an individualized sentencing determination? If you allow the defendant to preclude the presentation of mitigation to the point where you have a record like the one before you now, where you don't even know what you don't know, that individualized determination is simply not possible, and really neither is meaningful review of the trial court's determination, because you're working in a void. Going back to the defendant's ability to control his defense, I would say another thing that is different about the presentation of mitigation is that the defendant's autonomy interest is highest before the defendant has been convicted of anything. And I believe that was stated in Ferretta. So you have, at the point in time when a defendant is contesting his guilt or innocence, you have the highest degree of protection of that defendant's autonomy interest to present his case.
I guess the question that then I go to is, you've said a couple times that we would be sentencing in a void, but you've also conceded that it's really not a void in this case. The defendant did put on some mitigating evidence,
right? A small quantity, yes, Your Honor.
And so I guess my question is about discretion or granularity. I think you'd agree with me, wouldn't you, that if it was in fact a void, if there had been some suppressive effect that caused it to be a void, you'd have a stronger case. The fact that your client chose to put on limited mitigation seems to me, and I hope you'll answer, to be a purposeful modulation, a choice, as opposed to a blockage, right?
Your Honor, I agree that Mr. Bell acted purposefully. Yes.
Okay.
No. I just don't think that completely answers the question, because his autonomy interest has to be measured or balanced against his Eighth Amendment interest in not being sentenced to death without a full consideration of the circumstances and an individualized sentencing determination. So yes, he has the right to autonomy. He has the right to control how his defense is presented. He has the right to decline to call his family members or to answer questions about his background. That doesn't mean that the court and our judicial system has no responsibility to look at the fuller picture before sentencing him to the final punishment. And the reason for that goes back to the theme that death is different. There is a finality about the death penalty that simply can't be undone. There's no clemency that can be extended once someone has been executed. There's no second chance for somebody who changes their mind.
Let me ask you this, Counsel.
Yes.
The court ordered a PSI.
Yes.
In this case, and the PSI includes a supplemental information. The kid has some family history background. It has some background information, and I take it your position is that this is not substantial enough.
Yes, Your Honor. It's not only not substantial. It's de minimis.
But given, I mean, it does provide the court with some information about him, and is it your position that some of the information revealed in the supplemental part of the PSI were strong enough that the judge should have lit a light bulb in the judge's head that perhaps he or she should have asked for more information?
I think there are two pieces of information in response to that, Justice Lavarga. One, that you have a defendant who's inviting the death penalty, who has a conceded lifelong history of depression. And two, that you have a defendant who killed someone he had identified as a sex offender, who indicated, at least at one point in time, that he had been sexually abused, or that there was sexual abuse in his childhood. And I know the state pointed out that Mr. Bell said at sentencing that he had not had an abusive childhood. But a person can have a generally good childhood and still suffer an act of sexual abuse. We don't know what the story was, but those two things are not necessarily directly in contradiction.
Fair enough as to one of the people killed, right? There was someone else who was not an accused child molester who was a target of this defendant, right?
You're talking about the officer who survived the attack.
Yes, but
thankfully,
I mean, yes.
But yes, absolutely, Your Honor, and yet, indisputably, the defendant maintained all along that was one of the reasons he targeted this particular cellmate. And so Justice Lavarga, I would say that those are two things that should have warranted further exploration before a sentence of death was simply imposed.
Normally, because I used to get these PSIs all the time when I was a trial judge, and they'll say it was just a robbery case, just a robbery case, and grand theft or something like that, and you get a PSI. In those circumstances, you would agree that whatever's contained here usually is enough for the judge to make a decision as far as sentencing.
I would agree that it's often enough. I would also say, Your Honor, in my experience, I've seen PSIs for robbery that were much more comprehensive than the PSI in this case. This one, for one thing, identifies a couple of family members, but makes no effort doesn't indicate that any effort was made to talk to them. The defendant may not have signed a release. Mr. Bell may not have encouraged the investigator in preparing the PSI, but there's nothing preventing that type of investigation. You know, there's no law preventing the investigator from contacting people like family members simply because the defendant is not supportive of that. And I would argue that at the point in time when the PSI has been ordered, especially because here the record shows that the court ordered it in an abundance of caution because such minimal mitigation had been presented, but just enough, but not very much. In that circumstance, to simply say, well, the defendant's not cooperating, we can't investigate this, was not enough of an effort and didn't provide the court with any additional useful information that wasn't already in front of it. Just going back to the Eighth Amendment for a moment, Your Honors, if I may, it was Lockett, where the U.S. Supreme Court pointed out that the need for treating each defendant is in a capital case with that degree of respect due to the uniqueness of the individual is far more important than in non-capital cases. And that's something the court recognized also in Woodson, and I believe in Eddings and other decisions too. What I would say is that when you are looking at that balance between the defendant's autonomy and the judicial system's need for information before handing down a reasoned sentence that's going to yield an execution at the end of the process, that distinction between capital cases and non-capital cases has to come into play, that the autonomy interest, however important, can be respected without ignoring the possibility that there's significant mitigating evidence that's not before the court. You don't have to compel, or you can't compel, a defendant to testify. You don't have to force him to go through the motions of presenting a case that he doesn't want to present. But when you have all of the resources of the state available to you, there should be some more investigation into a person's circumstances and background before sentencing them to a punishment that you can't undo. The court has no further questions. I'll reserve the rest of my time. Thank you.
Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Jason Rodriguez, Assistant Attorney General for the state of Florida. In my time before the court, I will explain why the trial court did not fundamentally err in sentencing appellant Jesse Bell to death. And that's the first hurdle that this court needs to overcome, is that none of these issues were preserved below. And even when a defendant or a capital defendant enters into a guilt phase trial, the failure to preserve is a bar that can only be surmounted by a showing of fundamental error. Now, that's problematic in this case because of the lack of information that we have and the waivers that appellant Bell has continually put forward in the record before us. In this case, we have no fundamental error that's been presented to this court. This issue was not argued as fundamental error, and to the extent it was vaguely alluded to as a due process violation, this court has repeatedly held that conclusory assertions of error are simply not enough to present an issue to this court. Were we to get past that hurdle, the error is not fundamental in this case. There is weighty aggravation in this case, 3 of the most severe aggravators known to Florida's death penalty scheme, as this court has repeatedly noted. And in light of that and the mitigation that was presented, including the mitigation that was proposed or alluded to in appellant's brief, which was depression, which was considered by the trial court, sexual abuse evidence that was controverted by Bell himself, and I did want to point the court to the record on pages 199 and 599 to note that Bell categorically denied being sexually abused. So the argument that there is no conflict between his statements and the idea that he was sexually abused in the fact is not supported by the record. Were we to move past that, he didn't waive mitigation, and the Eighth Amendment, while it does require certain protections be put in place, considered reasoned judgment by a trial court imposing death, it does not require the trial court to perform the task of counsel for a self-represented defendant. Bell, in this case, stonewalled the trial court at every turn, as noted on the PSI on page 3. But he also admitted his competency report into evidence in mitigation explicitly. And the competency report contains a decent amount of mitigating information that the trial court could consider, including the extent of his depression. So for those reasons, the state would request the court affirm if it has no further questions of counsel.
Counsel, you're not getting away that easily. In Muhammad, we said that to be meaningful, the PSI should be comprehensive and should include information such as previous mental health problems, school records, and relevant family background. Is it the state's position that the PSI in this case met the Muhammad standard? And if the answer is no, you said the state doesn't have the responsibility to do the job of defense counsel. I'm wondering whether, however, the state does have a job to do here. Does the state have any obligation to make sure that the PSI is adequate to support the punishment that the state is advocating for?
So the answer to your first question is no. This would likely not have been sufficient under Muhammad if we're just looking at the PSI. We've got a predicate element, though, before we get to Muhammad, and that's whether there was a waiver of mitigation and a failure to challenge the death sentence. In this case, Bell challenged certain of the aggravators, including the contemporaneous felony aggravator. He challenged the heinous, atrocious, and cruel aggravator at the penalty phase and said his own death would be heinous, atrocious, and cruel if that's the standard. So we don't have that, and we have the presentation of mitigation, including 7 things that he testified to in the penalty phase. He never assaulted officers before. He suffered from depression. He took responsibility and pled no contest. He had good behavior in court. His family loves him. He's had good prison behavior since, and he's an honest person. Then we also have a competency evaluation done by an expert that contains additional evidence regarding the extent of his depression, including that he was on Prozac, lithium, Celexa, Zoloft, and has a long-standing history of depression that is presently under control of mitigation. So even though this PSI wasn't sufficient under Muhammad, we don't get to Muhammad at all when we've got his testimony and an actual expert report coming into the record. Second, regarding the state's obligation, this court has imposed a policy requirement. If we were to bypass all of that and say Muhammad applied, this court has imposed a policy requirement and deemed it as such. That's the language of this court, that all of this information should be in it. So we would have, on the one hand, a Muhammad error, but then we have another legal philosophy, judicial principle, that of invited error. And in this case, the PSI on page 3 specifically notes that the PSI could not be as comprehensive as usual because Bell prevented the release of information. And that's particularly critical in this case, where Bell was an interstate compact transfer from Kansas. It's not clear how much of these records the state of Florida could actually get, even if it utilized its best efforts, because we're not dealing with a Florida defendant. So to put the burden on the state in this case, where it's not even clear that the state could obtain the information using its best efforts, certainly is not an Eighth Amendment violation, and none of the cases from the U.S. Supreme Court support the idea that the state must go forward and, negotiate with other states in order to get mitigation information that may or may not exist, particularly when we have a competency report and his own testimony. So if there are there no further questions from the court? In that case, the state of Florida requests that this court affirm the judgment and capital sentence entered in this case. Thank you, Your Honors.
Thank you, counsel. Rebuttal.
Your Honors, I'm trying to remember whether it was Farr, but I'm remembering an old dissent of Justice Kogan from decades ago that really could have been written last week. This court has been struggling for years with how do we balance these interests. The interest of the defendant to choose not to present a mitigation case, the interest of the court and of the state of Florida in not simply executing people because they say they want to be executed, which is really participating in somebody's suicide. Our respect for the autonomy of the individual in any other circumstance causes us to try to prevent suicide, not to facilitate it. And so I think the court has an obligation in these invited cases to make sure that the court is imposing this penalty for for substantial reasons. Yes, Your Honor.
How do you respond to the state's argument on preservation?
As a practical matter, Your Honor, when you have a defendant at the trial level who basically invites the death penalty, that defendant is not going to preserve error. I think in Kraft, the court didn't really reach this issue and discussed it as under the harmless error standard as a discretionary decision of the trial court. But I would say, as I did in the briefs, that it could be looked at as fundamental error because the failure to consider mitigation, the simple acceptance of the defense case without looking further, vitiated the reliability of the result, and so rose to the level of fundamental error.
How do you respond to the argument by the state that in this particular instance, Mr. Bell introduced his competency report as mitigation? And in it, there was a lot of information about his background, his depression, his medication, and everything else. And what else do you felt was needed for the court to consider?
Your Honor, that's absolutely correct that was introduced. But that report didn't necessarily give the picture of a lifelong history of depression. It gave a picture of Mr. Bell at a specific point in time when he was being assessed for could he go ahead with these legal proceedings.
You would have preferred that there be an expert testimony.
That would have
basically
been
explaining his childhood, his depression, and his reactions and things like that. That would have been your preference.
That would be preferable, Your Honor, and that would have given the court more information to weigh against the circumstances of the offense and a fuller picture of Mr. Bell as an individual. Yes, I'm not saying that alone would have been constitutionally required, but that would have been something that could have been done. And again, we're working with omissions here. We don't know what we don't know. We can't say what would be in the record if the court had gone looking for some of the evidence that was suggested was out there. As for the defendant's records being in Kansas, I don't know the logistics of getting records from one prison system to another, but I would suggest that if you can move a prisoner from one state to another, you can also get his records to go from one state to another. What all of this goes back to, Your Honors, is that the defendant's autonomy interests and the court's responsibilities have to be viewed differently in a capital case because death is different, because of the finality of the penalty, because of its rejection of rehabilitation, because of its rejection of any possible future clemency for the defendant. The autonomy interests, which we already know are not absolute, can be respected while still requiring enough of an individualized sentencing process that the sentence satisfies the Eighth Amendment and not just the Sixth. We ask that you reverse if there are no further questions. Thank you.
We thank you both for your arguments in this case today. The court will now stand in recess and will reconvene for our virtual argument at 10:30.
All rise. Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
The court will now take up the case of in re amendments to the Florida Bar Rule of Appellate Procedure 9.130. Ms. Walter is recognized.
May it please the court. Good morning, Chief Justice Kennedy, justices. I'm Elaine Walter from Boyd, Richards, Parker, and Collinelli, appearing on behalf of the Appellate Court Rules Committee. As the court knows, this referral originated with a letter to the committee from Clerk of Court Tomasino. We were asked to provide rule amendments, to propose rule amendments to provide for the interlocutory appeal of non-final orders granting or denying leave to amend to a complaint to assert a claim for punitive damages. This request was made for two reasons. Pursuant to Globe newspaper, Company versus King, the appellate court's jurisdiction is limited to reviewing whether the trial court followed the procedural requirements of the punitive damages statutes. And two, even though no discovery of financial worth shall proceed until after the pleading concerning punitive damages is permitted, there is currently no avenue for immediate review of the trial court's statutorily required determination of whether there is a reasonable showing by evidence in the record or proffered by the claimant, which would provide a reasonable basis for recovery of punitive damages. As directed by the court, the committee submitted a proposed amendment to Rule 9.130 to authorize appeals of non-final orders that grant or deny a motion for leave to amend a complaint to assert a claim for punitive damages. This proposed rule was approved by a unanimous vote of the committee and also approved by the Board of Governors by a vote of 33-2. Additionally, in an effort to assist the court, the committee offered its independent evaluation of whether these new rights for interlocutory review should be created, and we recommended against such action. I'd like to explain our process. The committee treated this referral as a directive from the court, and it did so on two bases. The first was our own internal operating procedures, and the second was Rule of General Practice in Judicial Administration 2.140F2. Both of these provisions state, if the court refers a matter to a Rules Committee for consideration only and does not direct the committee to propose a rule change, and after considering the matter referred, the committee determines that no rule change is warranted, the committee shall submit a no action report to the court explaining its recommendation that no rule change is needed. But that's not what we had here. We were asked to actually propose this. So we didn't think it was sent to us for consideration only. So the proposed amendment is consistent with what the court had requested, and it can be found at what will be new Rule 9.130 sub 3 sub G. And it reads exactly as the court proposed in the letter through Mr. Tomasino. We did engage in further review. That was because certain members of the committee were concerned of unexpected consequences from the proposed rule change and the fact that it had twice been considered and rejected. The first time it was looked at was in 2016, and that referral was made by now Judge Kuntz, and it was based on SAP American Incorporated and Royal Flowers Incorporated. Again, the committee decided that orders granting or denying leave to assert a claim for punitive damages would be the best way to go. And that was the initial recommendation by the subcommittee. However, the full committee voted it down based on this court's rationale in Martin Johnson v. Savage. And that rationale was litigation of a non-issue will always be inconvenient and entail considerable expense of time and money for all parties in the case. For example, a party injured by an erroneous interlocutory order may eventually win the case, mooting the issue, or the order may appear less erroneous or less harmful in light of the development of the case after the order. So that proposed amendment did not pass. It also didn't pass in 2018. The 2018 referral was based on Levin versus Pritchard. During this referral, the committee conducted a 50-state survey to see how this issue was being handled elsewhere. We found that some states let the courts determine if they want to take an interlocutory appeal of such an order. Some prohibit punitive damages altogether, and some don't require court permission to allege punitive damages. But no other state has a rule like the one the committee proposed here. That referral was also voted down in the subcommittee and was not reviewed by the full committee. We do have something that you might want later. Let us know. The agenda and minutes for that referral were not filed with the court, but we do have the research available if the court would like us to supplement the record. The process for this referral related to the committee reviewing the letter as a directive. So we didn't do any substantive research. What we did do was try to determine how this proposed rule change may impact the district courts of appeal. We reached out to a number of individuals and entities to see if there was data on the number of motions for leave to amend to assert punitive damages, as well as certiorari petitions when those motions were granted. The entities we reached out to included Lisa Keel, a former state court administrator, the Clerks Association, the two biggest providers of case management docketing systems for the trial courts, which encompassed about 70% of the Florida counties, and the District Court of Appeal clerks. There was no information available from any sorts. Therefore, the committee wanted to provide the court with the vote on whether it would have recommended the proposed rule change, but for the court's directive. In a vote of 25-9, the committee determined that it would not have proposed that amendment. The overall position against the amendment throughout the process were that the committee had considered this twice and voted it down. There were no statistics available to determine the impact of the proposed amendment. The recent appellate jurisdictional change for appeals of county court orders created a much larger caseload for the DCAs. The courts are already addressing the cases through certiorari. The current review procedure through certiorari is adequate and protects litigants' relative rights and positions. A full interlocutory review would slow down the case. And there are some other concerns that I'm sure Mr. Gowdy will address based on the comments of Florida Justice Association and the comment he filed along with Megan Keith-Luca. The overall positions in favor of the proposed amendment were the court's directive was clear and it was well supported by the recent case law requesting this amendment. There have been 11 opinions or concurrences in the last 5 years asking for this amendment to happen from the DCAs. It will protect the defendant's right to be free from financial worth discovery until appellate review is afforded. The limitations of the certiorari standard as described by the DCA opinions were apparent in those opinions. Interlocutory review seems to align with the purpose of the statute more closely than certiorari. The fact that punitive damages is a game changer, which is also in those opinions. And there are also other concerns that will be presented by the proponents, commenters.
Ms. Walter,
yes, sir.
am I correct that the standard for cert review might not give relief in a case where there was an abuse of discretion in allowing the amendment, because it might not reach to the departure of the essential tenets of the law standard? I didn't say that exactly correctly. Isn't that correct?
Yes, you are. You're correct.
So you could have a wrong decision that allows discovery to go forward. You could take all this time to have an appeal through the cert mechanism, but then you could get a bad result just because the standard is wrong. It's sort of baffling to me why it wouldn't make sense, if it does take more time, to take a little time to get it right than it would to recognize that we're just going to keep in place a standard that could get it wrong on appeal. Can you address that for me?
Yes, I can, Your Honor. I think the concern of the committee was that they wanted to make sure there was a level playing field, and they feel like punitive damages somehow levels that playing field with an award, and that even though the standard may be less on certiorari, that there's still review in some way of that decision.
But how does it level the playing field if one side can get a bad trial court ruling but not get relief? I mean, it seems what levels the playing field is if both sides have an opportunity to get the relief that they would be entitled to, and that is correction of erroneous trial court error at the proper time when it can prevent the harm that the statute's designed to prevent.
I think the discussion in the committee, Your Honor, focused on the fact that the same thing can happen with a motion for summary judgment or some other sort of interlocutory orders, and the case can continue on to trial, all the way through trial. So it seemed that the protections to some of the committee members did not need to be afforded on a motion for punitive damages.
I don't understand how that point relates to the leveling the playing field. Explain what I'm missing about that.
Yeah, and I'm sorry, I might have misspoke, Your Honor. The reason
Which part was a?
the leveling the playing field, I think I put it in out of context. So when we proposed the rule, across the board, everybody said when it came time to vote that this should be, if it is done, it should be done for both orders denying or granting motions for leave to amend, and not one or the other. So
And
that was
is
sort of
what
the,
it is proposed to be
correct.
for granting or denying. So that what we have
Correct.
before is something that is perfectly equal.
Correct. So I think I misspoke there, Your Honor.
Counsel, can I ask you to perhaps discuss some of the reactions the committee and the Board of Governors might have had to the arguments that there are other ways to prevent the disclosure of confidential financial information, or generally to unring the bell, or unscramble the egg, if you like, so that the harm that this rule is designed to address would not materialize. Can you talk at all about the consideration of those factors and where you landed?
Yes, Your Honor. As far as the Board of Governors, I just don't know. I was not at that meeting. We didn't get a report from them. We simply got a vote from them. So I can't address their process. As far as the committee, the broad-based sentiment of the 25 people who voted that they would have not voted for this amendment, but for the directive of the court, was that that the certiorari was effective, and that the trial courts are doing their job and they're looking at the evidence and they are weighing it. And so it doesn't need to be taken on interlocutory review. I'm not sure if that answers your question, but that was the discussion.
Well, I think in some of the comments we've received, there's this discussion about how you might enter a protective order or take other steps to prevent the disclosure of confidential financial information. I'm just wondering what degree, the degree to which the committee considered that as an alternative and why it wasn't adopted.
I'm not sure the committee thought that they could adopt that. They were trying to stay within the parameters of what the court asked us to do. And when we looked at it, we didn't think that was part of, for lack of a better word, the directive from the court.
Ms. Walters, I have a question. In light of the fact that this court has recently changed the summary judgment rule, affording the trial courts far more discretion in granting them, and how would that affect the situation where if we just let the rule stay the way it is and an amendment is allowed, and then later on, given the new summary judgment rule, the court can always grant summary judgment on the question of whether punitive damage should be allowed or not? Wouldn't that, what I read in the materials, apparently there is one federal district court in the Southern District of Florida that follows that procedure, that doesn't entertain motions for amendments of punitive damage until there's a motion for summary judgment and it's been passed. It's gotten by a motion for summary judgment. Something like that. Why can't that be the solution? And I would think that once you argue the motion of summary judgment and say it is granted or denied, and there's at least a greater factual finding that apparently doesn't exist under the present situation.
My answer is twofold to that, Justice Labarga. I think the majority of the committee would believe that that is appropriate, that can be addressed on summary judgment on whether or not the punitive damages claim should go to the jury. I think a minority of the committee, in that discovery, that financial discovery, and we shouldn't have to until it's been determined.
Gross negligence or whatever predicate there is, making that decision first before, anyone's allowed to do any kind of discovery. It would seem to me that under the present, the new motion for summary judgment, before, all someone had to do was just file some kind of affidavit and the judge would have to deny it, summary judgment-wise. But today, under the new rule, that's not the case. So I would suspect that once you get the motion for summary judgment, the judge can always grant it in that junction and not allow it. And how would that be appealed?
Again, Justice LaVarga, I think that it can be looked at on summary judgment, but that's not the procedure we have in place right now. The procedure we have is through a motion for leave to amend, and our review procedure is through GLOBE and looking at the procedural ramifications only. So while we
And
could...
Ms. Walter, how would summary judgment, that motion, if it was on punitive damages, would have to be done after discovery, and the statute that's in place is designed to prevent discovery that should not be had because there is no basis for pleading a punitive damages claim. So we're trying to come up with a procedure that effectuates substantive law, and one that doesn't allow review, doesn't really effectuate substantive law. Why have a procedure at all? So this procedure would give review before the discovery was had, which is I think the point of the statute. So I'm struggling to see how summary judgment really has anything to do with this.
Correct, Your Honor. And I do think, and part of the minority's position was that this particular type of review, changing it to interlocutory review after the motion for leave to amend, would enable the courts to look at, the appellate courts to look at the substance of the proffer to see whether it was punitive damages discovery was available at all. And that was one of the concerns of the majority. As far as the summary judgment being the vehicle for bringing a punitive damages motion, I'm not certain how that would work, Your Honor. I realize there's one district court that's doing that. But as far as review after the fact for summary judgment, it could be looked at, but Justice Lawson, you are correct that the discovery would still be out there, and it seems as if the statute would prevent that. And I see I'm very over my time.
Ms. Walter, you are. I will nonetheless afford you 2 minutes for rebuttal, and probably more if you want it. But we are going to move on now.
Thank you, Chief Justice.
Okay, thank you. So I now recognize Ms. Gooden.
Good morning. May it please the court. Kansas Gooden on behalf of the Florida Defense Lawyers Association. The FDLA supports this rule amendment. Allowing a plaintiff to proceed with a punitive damage claim is a game changer in litigation. It exposes defendants to substantially higher judgments, and it inflates settlement values. It subjects defendants to damages which are not covered by their liability insurance policies. It subjects defendants to financial discovery that would otherwise be off limits. Importantly, defendants who are natural persons have a constitutional right of privacy to their financial information. There's a legitimate expectation of privacy. In addition, defendants have a substantive right under the section 768.272 to be free from financial discovery until a certain showing is made. Presently, an order adding a claim for punitive damages is reviewed under a petition for writ of certiorari. However, this review is limited to only whether the statutory procedure is followed. The sufficiency of the evidence or proffer is not reviewed. This procedure, or rather a lack of appellate remedy, does not sufficiently protect the defendant's constitutional or substantive rights. This rule amendment would help protect those rights. There would be an adequate appellate remedy to review and to ultimately protect that private information where the amendment for punitive damages is not warranted. At least 19 judges from 3 different DCAs have recommended this amendment in their opinions. I also want to address some of the concerns of the other commenters about overburdening the court system. First and foremost, constitutional rights of the parties must be front and center. A defendant's constitutional rights should not be downgraded simply because an appeal may result. The concern that the amendment may result in too many appeals highlights the importance of this rule amendment. Punitive damages are intended to be the exception, not the standard. The legislature limited their applicability to certain situations. The text only allows them in a narrow set of circumstances. If punitive damages are being broadly sought, then the narrowly tailored statute is not being applied as written. In any event, the court will not be overburdened with appeals. There may be a slight initial uptick in appeals where litigants are allowed for the first time to seek review on this issue. Once case law is developed, however, there will be guidance. The trial courts and parties will operate with greater clarity, and they will know exactly what will lead to an amendment and what won't. This will lead to less appeals in the long run. It will also promote settlement in these cases. For these reasons, the FDLA requests that this court adopt the amendment to Rule 9.130. And if nobody has any questions for me, I will cede the rest of my time. Thank you.
All right, thank you, Ms. Gooden. Mr. Gowdy. There you are.
All right. Good morning. I was somewhere in the internet for a couple minutes. I'm sorry if I didn't hear what you said, Chief Justice. May it please the court?
Please proceed.
Thank you for giving me the opportunity to speak to you today on behalf of myself, my fellow appellate practitioner, Megan Pekluka, and also the Florida Justice Association, which followed a separate comment. I wanted to talk about 3 points in my time, and I'm going to move the order around given the conversation, but the 3 main points are, I would urge the court to take a holistic approach when looking at Rule 9.130 and consider effective case management at the appellate level, similar to what you're about to review from the work group on improved resolution of civil cases. Number 2, the game changer rationale is not sufficient, and that can't be a basis for a non-final appeal. And 3, where I'm going to start and had hoped to end, was the better ways to address discovery of confidential financial information and uninsured losses. I want to be clear, especially with regard to Justice Lawson's questions. The way Judge Reiskamp did that's the Southern District of Florida opinion, and I've had cases in front of him. He would not allow the discovery on the confidential financial information until you prevailed at trial as a plaintiff. And other courts in the federal courts, there was a New York opinion I cited in my comment, they'll ratchet back a little and they'll wait until there's been a ruling on the summary judgment. So it's not, Justice Lawson, the discovery doesn't go forward until later on that particular information. So just because you're granted leave to amend, the way the federal courts have dealt with this, because you don't have to seek leave to amend there, you can plead it as a matter of right. They've said, you've pled it, but I have discretion in how I'm going to order this discovery. I'm not going to allow this discovery until later in the process. It may become unnecessary if you lose on your punitive damages claim.
So, Mr. Why don't we start there then? I guess, to what question at issue is this discovery or such discovery relevant prior to a verdict? Is it relevant to absolutely anything prior to a verdict?
It's not. So really, the problem is it's a logistics problem. If you get the discovery after the liability finding, then you have a short amount of time to prepare. But it's really just relevant to the phase 2 portion of the trial. And I wanted to point out, in a lot of the cases I deal with, the plaintiffs don't request this information anymore. But this rule will be triggered whether, even if a plaintiff is not requesting or doesn't intend to request this information. There's two types of cases I see routinely where it's the plaintiff doesn't need or want it. One is if you're dealing with a public company, that information you can get from the SEC. You don't need to go through the discovery process. Two, punitive damages are pled against individual defendants, and that's what Ms. Gooden was talking about, this constitutional right. She said natural defendants. But often that is done more as a trial strategy, not for purposes of getting a large judgment against that individual defendant. So I don't see, and it's not overly intrusive. It might be just what's your net worth, period. So there's lots of cases where I think this has changed in the last 15 years where plaintiffs aren't asking for this information. But if they do, Judge Reiskamp and other federal district judges had ways to deal with this under the federal rules of civil procedure to try to best protect those rights. And I want to kind of bleed into the game changer rationale. There's lots of non-final orders that are game changers and that affect statutory rights. An order denying a motion for summary judgment based on the statute of repose or the statute of limitations, that's not appealable right now. I get those calls, oh, I want to appeal. You can't. I get lots of calls where I tell people you can't appeal. You have in our Constitution, we have a right to an appeal of a final judgment. We don't have a right to an appeal of every non-final order. We do have a right to have judicial review, and that's the trial judge. And that's just the only way the system can sustain itself. And in the federal courts, the way they've dealt with this, and this goes to my holistic approach, trying to figure out what type of non-final orders should be allowed to be reviewed on appeal, they have the Collateral order doctrine, and it has 3 elements. Conclusively determine the disputed question is the first element. Now, so for punitive damages, the order granting leave to amend does not do that. In the cases I handle, if we are granted that leave to amend, the defendant often then will follow that up with a motion to dismiss for failure to state a cause of action for punitive damages. And then they'll follow that up with a motion for summary judgment. And that's the first time the defendant is allowed to put in their own evidence, because they're not allowed to do that on those first 2 motions for leave to amend and motion to dismiss. They're not allowed to put forward evidence. So they get to put that in at the motion for summary judgment. They'll file that motion. And then if that's denied, I usually see them file a motion for reconsideration and a motion for directed verdict. So you would fail under the federal Collateral order doctrine on the first element here. The second element is resolve an important issue completely separate from the merits of the action. So a fair amount of our Rule 9.130 non-final orders would fall under that. Things like arbitration, venue, personal jurisdiction. So they're separate and they're an important issue that you want to get resolved up front. Punitive damages are not separate. They are intertwined with the merits. And so the federal courts, in order to keep an efficient system, have recognized that shouldn't be allowed. I do want to, with my brief remaining time, talk about a holistic approach. This court is about to get comments on the work group on improved resolution of civil cases. I would encourage you to read endnote 9 of that report. It expressly states that the work group did not look at appellate procedures. This year, the legislature has increased the workload of appellate courts by transferring county appeals from the being in the circuit courts to the DCAs. We still don't have, as you heard from the committee, we don't have any statistics on what this impact is going to be. I think before the court just starts adding things to 9.130, it should look at perhaps trimming 9.130 so that we can have a more efficient court system for Floridians. If I could have 1 second to conclude.
Sure, you can go ahead.
My fellow appellate practitioners, we like appeals, but I realize it's really not in the best interest of Floridians to have so many appellate options. It slows the trial process down. Every time an appeal goes up, a trial judge is not going to set that case for trial. And we already have the writs of certiorari that are constitutionally based, and you can't change those. You can deal with 9.130, and I think if anything, the court ought to be looking at looking back in time and seeing whether all those are really justified anymore, not adding things at this point. Thank you for the opportunity to address and the additional time, Mr. Chief Justice, and if there aren't any questions, I will be quiet.
My only question is, so if we could figure out procedures to speed these up, then you would be fine.
Well, I think we are very concerned about the delay.
I mean, because constitutionally, they can get to the appellate court and slow things down. So your problem with it is that it could slow it down more.
Well, I just don't know why it's necessary to have this be reviewed.
But the concern that you're raising is a valid one. I mean, we don't want to do things that unnecessarily delay trial court proceedings in any case. I mean, I'm sympathetic to that.
I think there's more creative solutions. I didn't even get to it.
Okay.
The uninsured losses, if that's the concern, then change Rule 9.3100 about the bond amount when you're dealing with punitive damages. But adding, yes, Chief Justice Lawson, the main concern here is you're going to slow down trial proceedings, which is contrary to what your workforce is trying to solve, because you're going to allow more appeals. It seems to me, after you do your workforce review, and I know the comments are due at that, I think an earlier.
Well, but I think the point that Justice Lawson is making is it's not going to really allow necessarily more review. It's just going to change the scope of the review. Move it from the cert review to the non-final appeal.
But that will be more appeals, because the narrow, as many as you see, there's more than enough times, Your Honor, that appellate lawyers will tell someone you can't appeal that because the narrow scope of review. So you are going to have more appeals. I can guarantee you that. I think Ms. Gooden would acknowledge that. Now, how many more?
Yeah.
As you heard from the committee, we don't know.
Okay.
We don't have the data. And I think all I was trying to suggest is, unlike the Cohen Collateral Order Doctrine, the order granting leave to amend is not the final say. There's usually 2 or 3 more rulings from the trial court about punitive damages. And what these federal courts have said is, I'm not going to give you that discovery until we have more rulings on the merits of your punitive damages cause of action. And that seems to be a more efficient way to deal with the harm that you're talking about, Justice Lawson, and not cause the side effect of slowing down the court system.
Right. Thank you, Mr. Gowdy.
Thank you.
And I'll now recognize Ms. Walter for rebuttal or additional comments.
Thank you, Chief Justice Kennedy. At this point, if there are any more questions from the court, I'd be happy to take them. Otherwise, I am happy to not. I'm not sure there's much else I can say that will help you.
Well, I don't see anyone looking like they're going to ask a question. So we want to thank all 3 of you for your arguments today. We appreciate the work of the committee and the other people who've been involved in the process. And so that concludes our consideration today and this session of the Florida Supreme Court.